Thank you for listening to Lone Star Community Radio. This program was broadcasted and recorded live from the LSCR studios in downtown Conroe, Texas. Lone Star Community Radio is supported by listeners like you. Donate and sponsor today. For more information on getting involved with Lone Star Community Radio, contact us at lscrstudios@gmail.com or visit us online at www.irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Tony Collins, an attorney licensed attorney in Texas. The Legal Connection Show airs on Tuesdays at noon to 1 every week, and you can get us on FM 104.5 and FM 106.1. If you missed part of the broadcast or you want to listen to it again, you can go to irlonestar.com, and all of the episodes that we have videoed and recorded will be on the site under the Legal Connection Show. And you can also go to our Facebook, The Legal Connection Show, and get our the recorded replays. Or you can go to our YouTube, The Legal Connection Show. I believe it's .com. I'm not really sure, but you can re-listen to any of our broadcasts if you missed them or you want to hear them again. And so today our show is going to be the final in a series of 3 parts for Roe v. Wade. And our first part, if you want to go back and listen to it, talked about the actual original Roe versus Wade opinion and what it actually was about and what it said. I mean, we hear about it, but most of us have never read it or knew anything about it other than it had to do with pro-choice and pro-life rights, and it was a landmark decision back in the early 70s, and I believe it was 1973 when it came through. And so what's been in the news lately is that it may be overturned because there was a new case in Mississippi to challenge the constitutionality of the abortion laws in the various states, and this one was in Mississippi. So the we're actually going to talk about it today, but the new case is Thomas E. Dobbs, the state health officer of Mississippi Department of Health, as petitioners versus the Jackson Women's Health Organization. And the Supreme Court granted certiorari on that, and they heard oral arguments, and it actually, although it hasn't been, the Supreme Court hasn't come out to the public with their decision, it was leaked, just like the first one was about 50 years ago, Roe v. Wade. And so I have a copy of that draft leaked opinion that was written by Justice Alito, and we're going to go over the final part of that, so you can understand what all of the I don't want to say confusion, but what all the interest is in this particular case. And what I also did last week, and I'm going to continue on with this week, is to talk about the actual people involved in the cases. While I don't have a lot of information about Thomas E. Dobbs, we're going to find out about that when we go over part of the case. I do have some information on the actual players back in 1970, Jane Roe versus Wade. And what we learned last week was that Jane Roe was a pseudonym for a real person's name. Her name was not Jane Doe, which is what they call, bodies that they find. Jane Roe was what they used, and her name was actually Norma McCorvey. She was actually alive until 2017, and she lived in the Katy area. In fact, Roe v. Wade was a Texas case that was brought in the federal district court, and they won in district court, lost in the Fifth Circuit, and then won at the United States Supreme Court level when they used legal gymnastics to get to the result what they wanted, which was to find that the state of Texas laws were unconstitutional with regard to whether or not they could control a woman's right to an abortion. The Texas law at the time was very similar to many laws that we had in a majority of the states. And it should be a state issue. That wasn't what was brought up in Roe v. Wade. In fact, they argued the constitutionality of whether or not the Texas law was unconstitutional under many different amendments in a lot of different parts of the Constitution, but not the 10th Amendment. The very amendment which I've always thought was an issue in many different areas in our law. The 10th Amendment basically says that any laws that aren't specifically expressed to be addressed in federal court should belong to the state to decide, and that's gun control. Here would be whether someone's pro-life or pro-choice, and all the different areas of law that aren't expressly given to the federal government are reserved to the states. That's what the 10th Amendment is. Because the word privacy is not even in the Constitution, and because there's expressly no law that allows the federal government to make rules for whether or not a woman has the right to have an abortion or not, medical issues, that would be reserved to the states. And so that's pretty much the direction that we're going to see that the Dobbs versus Jackson Women's Health. Let me see what the name of it is. Jackson Women's Health Organization. That's pretty much the way I believe that Justice Alito has reasoned that Roe was just wrong in the way it was decided. And I guess for our listeners and viewers to know a little bit more about it, the Supreme Court isn't, or they're not supposed to, be trying to make law. They're trying to determine whether or not the law is done by the legislature or by the states, but are they're deciding whether or not the law was followed. But they're not supposed to be making law. But what they do is they interpret. They decide whether or not it passes the burden by the I guess the courts and the states and the legislature to and I forgot what the name of it was, and I made the highest rating constitutional law. I should know this stuff, but it was 20 years ago. Whether or not it meets the I guess the controls of the Constitution. And so anyway, Justice Alito wrote a very, very good opinion, in my opinion, that followed the guidelines of the Constitution and basically said the state should get to decide. I think that's what we're going to see when we read it in more detail in a little bit. But anyway, so Norma McCorvey lived in the Katy area. She died in 2017. She never met the children that she gave up for adoption. And just a slight backstory on that, Norma McCorvey was a Texas woman who wanted an abortion. She met with an attorney, Larry McCluskey, in the Dallas area. They were looking for a woman, some young Harvard, I think they were Harvard graduate women, were looking for somebody that could be their person to have standing to bring a case to the Supreme Court to argue that this law was unconstitutional, but you can't do that unless you have standing. Norma McCorvey was pregnant and wanted an abortion, but she allegedly could not afford to get an abortion. She couldn't leave the state to go to a cheaper state because they were offered in other states. And she was past the 15-week mark, and in Texas, the law was that you can't get an abortion after 15 weeks. And so she was hooked up with these two young attorneys who were close to her age. Sarah Weddington, I think, was one of them, and the other was, I think her last name was Collins. But let me see what their names were. Well, anyway, she could have gone to Oklahoma for it, but and she didn't have any money. She was really poor. She was born on the wrong side of the track. She got in trouble a lot with the law, and she wanted an abortion. She got hooked up with these two attorneys that basically dragged their feet and had no intention of helping her get an abortion, although Sarah Weddington had actually gone to Mexico and got an abortion earlier. She couldn't afford it. So their argument was, you shouldn't take this right away from somebody who should have the right to control her body, the whole pro-choice movement. And so they brought it to court. During that period, though, these cases last a long time, she had the baby. She couldn't get an abortion. They didn't want her to have an abortion. They wanted her to be the figurehead for it. And so Larry McCluskey actually arranged to have her adopt the baby that she had adopted. She had 2 babies previous to this. Her mother adopted one of them. She was against her will, but she knew her. Then she had another one that was adopted. She knew those 2 children, but she never met the 3rd child, the one that was the baby that gave her standing to be the Jane Roe and Roe versus Wade. And so what I looked up was this woman was born in 1970. What happened to her? And I found an article on her. And so we're going to talk about the baby, who is now a 52-year-old woman. She might be 51, but she's ready to be 52. That where she lives and what happened to her and what have you. So Norma McClusty had this baby in Texas and gave the baby up for adoption. And here is what we know about that woman. She's called the Roe baby. Her name is Shelley Lynn Thornton, and she lives in Tucson. And Norma McCovey. So I'm just going to read this article. The article is written by, I guess not Politico, but another news organization called Politics. So, and it was actually written last year. This woman kept her privacy for a long time. She didn't want to talk to anybody about it, and I kind of really don't blame her. But I don't know if you can see this picture of her, but this is a picture of the actual Roe v. Wade baby, Shelley Lynn Thornton. I guess she's got vineyards or something in the background. I'm not really sure, but we're going to find out a little bit about her. All right, so Norma McCorvey, the plaintiff in Roe v. Wade, never had the abortion she was seeking. She gave her baby up for adoption, and then now that baby is not just an adult, she's 51. After decades of keeping her identity a secret, Jane Roe's child was chosen to talk about her life. Has chosen to talk about her life. She kept her privacy, and as you'll see, she didn't know anything about Roe v. Wade until she was an adult. Nearly a half century ago, Roe v. Wade secured a woman's legal right to obtain an abortion. Of course, that's, kind of, I'm going to add in there that you could get an abortion, but you had limits to when you could get that abortion. You could get an abortion in Texas before 15 weeks. So if you found out soon enough, almost all 50 states allowed it. But before that, and up until the 1950s, the abortion laws were very strong and a part of our state laws and not a part of the Constitution, but it was prohibited for the most part, at least in the first 15 weeks. The ruling has been contested with ever-increasing intensity, dividing and reshaping American politics. And yet, for all its prominence, the person most profoundly connected to it has remained unknown. The child whose conception occasioned the lawsuit. Rose I'm going to kill this word. Pseudonym plaintiff Jane Roe was a Dallas waitress named Norma McCorvey. Wishing to terminate her pregnancy, she filed suit in March of 1970 against the Dallas County District Attorney Henry Wade, challenging the Texas laws that prohibit abortion. Norma won her case, but she never had the abortion. On January 22, 1973, when the Supreme Court finally handed down its decision, she had long since given birth and relinquished her child for adoption. The court's decision alluded only obliquely to the existence of Norma's baby. In his majority opinion, Justice Harry Blackmun noted that a, quote, pregnancy will come to term before the usual appellate process is complete, end quote. The pro-life community saw the unborn unknown child as the living incarnation of its argument against abortion. They came to refer to the child as the Roe baby. And I will add that, we talked about this in the previous segments, that one of the big arguments was there's no standing. She's not pregnant anymore. This case, no one has standing to bring a case that she's entitled to an abortion because she's already had the baby. So, and she's far past any of the arguments they even had in Roe that it would be her choice, because they divided in Roe. They made this. They divided the argument about when abortion should be a woman's decision into trimesters. So the first trimester, it was always the woman's decision. The second trimester was a decision to be made for, whether or not it was in the child's best interest or the woman's best interest. And then the third trimester, it was whether or not it was it would endanger the child. And so when they broke it down, there was no longer any argument about it. She already had the baby. And then we also know in our previous segments that Norma McCorvey was not even invited to take part in the, I guess, celebration they had in winning this, landmark case. The attorneys and the movement really didn't want to have anything to do with her, because she was a waitress that kept getting pregnant that had been in reform school that didn't look good to them. And so in interviews with her, she said that she didn't even know that it had been overturned until she turned the TV on. So it's kind of a sad, I guess, portrait of our politics and our media, that they really were just using this woman and her baby too, for that matter. Of course, the child had a real name too. And as discovered, the child's name and the child's identity had been known to just one person, an attorney named Henry McCluskey. McCluskey had introduced Norma to the attorney who initially filed the Roe lawsuit and who had been seeking a plaintiff. So they were just plaintiff searching. He had then handled the adoption for Norma's child. But several months after Roe was decided, in a tragedy unrelated to the case, McCluskey was murdered. So this is just tragedy all the way around. So he was the only one that knew, and then he was murdered. Norma's personal life was complex. She had casual affairs with men, one brief marriage at 18. She bore 3 children, each of them placed for adoption, but she slept far more often with women and worked in lesbian bars. Months after filing Roe, Norma met a woman named Connie Gonzalez, almost 17 years her senior, a mother figure, and moved into her home with her. The women painted and cleaned apartments in a pair of buildings in South Dallas. A decade later, in 1981, Norma briefly volunteered for the National Organization for Women in Dallas. Thereafter, slowly, she became an activist, working at first with pro-choice groups, and then, after becoming a born-again Christian in 1995, with pro-life groups. Being born again did not give her peace. Pro-life leaders demanded that she publicly renounce her homosexuality, which she did at great personal cost. Norma could be salty and fun, but she was also self-absorbed and dishonest. And she remained so until her death in 2017 at the age of 69, fundamentally unhappy. Norma was ambivalent about abortion. She didn't care. She no more absolutely opposed Roe than had ever absolutely supported it. She believed abortion to be legal for precisely 3 months after conception. So she had made up her own mind, pretty much almost like the legislature had. A position she stated publicly after the Roe decision and her religious awakening. She was ambivalent about adoption, too. Playgrounds were a source of distress. Empty, they reminded Norma of Roe. Full, they reminded her of the children that she had to let go. Norma knew her first child, Melissa. At Norma's urging, her mother, Mary, had adopted the girl, though Norma later claimed that Mary had kidnapped her and forced her to sign the papers against her wishes, telling her that they were just insurance papers. Her second child, Jennifer, had been adopted by a couple in Dallas. The third child was the one whose conception led to Roe. Having never been given the matter much thought, that the plaintiff who had won the legal right to have an abortion had in fact had one, but as Justice Blackmun noted, the length of the legal process had made that impossible. In early 2010, that Roe had not had an abortion brought people to wonder whether the child, who would then be an adult of almost 40, was aware of his or her background, Roe might be a heavy load to carry. And I wonder too if he or she might wish to speak about it. So anyway, over the coming decade, my interest, as well as many reporters, would spread from one child to Norma McCorvey's other children, and from them to Norma herself, and to Roe v. Wade, and to the larger battle over abortion in America. The battle is today at its most fierce. Individual states have radically restricted the right to have an abortion. A new law in Texas bans abortion after about 6 weeks and puts enforcement in the hands of private citizens. The Supreme Court, with a 6-3 conservative majority, is scheduled to take up the question of abortion in its upcoming term, and it should well overturn Roe. And we already know that the opinion's been leaked, the one that's written by Justice Alito, and it is going to overturn it. And what we are going to read about shows that it is very well, it's well reasoned and well written. And Roe was just a legal gymnastics to get to a means, and really wasn't supported by the Constitution or the law. Now, that doesn't mean that abortion should be outlawed. That means that each state will have the authority to make, through their legislature, the law that they want to uphold on whether a state should be pro-choice or pro-life based on its abortion laws. Texas is very much so pro-life, and with banning abortions after 6 weeks, that is highly supported by that, and it's a popular law in Texas as well. So I think the Texas citizens have spoken, loudly with our own legislation. So anyway, Norma's longtime partner, Connie, stood by Norma through decades of infidelity, combustibility, abandonment, and neglect. So this is her 17-year senior, lesbian lover. In 2009, 5 years after Connie had a stroke, Norma left her. I visited, I didn't visit, but the person that was writing this article said she visited Connie the following year, then returned a second time. Connie had alerted her to the existence of a jumbled mass of papers that Norma had left behind in their garage and that were about to be thrown out. Norma no longer wanted them. So this particular reporter at Politico bought the papers from Norma, and they are now in the library of Harvard. Norma had told her own story in 2 autobiographies, but she was an unreliable narrator because she lied so much. The papers helped establish the true details of her life, though, and found in them were a reference to the place and date of the birth of Roe baby, as well as to her gender. Tracing leads, it was found that this is how they were able to locate the actual Roe baby in 2011. Her name had not been publicly known until 2011, and it was Shelley Lynn Thornton. This reporter did not call Shelley. In the event that she didn't already know that Norma McCorvey was her birth mother, a phone call could have upended her life. Instead, the adoptive mother, Ruth, was called, who said the family had learned about Norma. She confirmed that the adoption had been arranged by the murdered attorney, McCluskey. She said that Shelley would be in touch if she wished to talk. Until such day, and I know also that Shelley had learned by reporters back in 1989 when she was 19 that she did already know that she was the Roe baby when she turned 19, but she didn't know before that. Until that day, this reporter decided to look for her half-sisters, Melissa and Jennifer. She found and met with them in November of 2012, and she said that they had told Ruth. But this is kind of giving this person a say they've done more than they have because they'd already known about it. Shelley then called to say that she too wished to meet and talk. So Shelley, the Roe baby, now wants to talk. She especially welcomed the prospect of coming together with her half-sisters at the age of 40. She told me that the next month when she met them for the first time on a rainy day in Tucson. Now, her sisters were born in 1964 and 1968. So they are still, I want to say they're probably in their 60s now, but all the girls are close in age, 64, 68, and 70. They were born within the time span of what a normal family, if she hadn't put them up for adoption, would have been. So anyway, she met them for the first time in Arizona, and she said she wanted to unburden her secret, which is still, this is poetic license because we already know that she knew. And she probably had met them long before. Secrets and lies, like the two worst things in the whole. She said she'd been keeping the secret from the public and she didn't like it. Anyway, this goes on to say that Ruth had grown up in a devoutly Lutheran home. She was born June 2nd, 1970. She was, I need to go back just a little bit to kind of give some context to this. Henry McCluskey turned to the couple raising her second child. They had already adopted one child. They decided they wanted to adopt another. The girl was born in Dallas Osteopathic Hospital on June 2nd, 1970. They did not join either of her older sisters. I don't know what that means. She became instead, with the help of the McCluskey, the only child of a woman in Dallas named Ruth Schmid and her eventual husband, Billy Thornton. So this is kind of weird because they're talking about this woman having this being their second child, and then they say it's their first, so that's confusing. Ruth named the baby Shelley Lynn, and so this Billy, I guess not Billy Bob Thornton, but Billy Thornton and Ruth Schmidt apparently stayed together and were still together, and so we're a happy home for this child. Ruth had grown up in a devoutly Lutheran home in Minnesota, one of 9 children. In 1960, at the age of 17, she married a military man from hometown, and the couple moved to the Air Force Base in Texas. That same year, Ruth learned she couldn't conceive. Ruth met Billy, the brother of another wife on the base. Billy Thornton was a lapsed Baptist from a small town in Texas, tall and slim, with tar black hair, as he put it, a deadbeat, thin, narrow mustache that helped him buy alcohol since he was 15. Billy had fathered 6 children with 4 women. Ruth and Billy ran off, settled in the Dallas area. So I guess Ruth had a lot of step siblings. Years later, Billy's brother adopted a baby girl. Ruth decided she wanted to adopt a girl too. That's when they adopted Shelley. And without getting into what appears to me to be a really long, drawn-out, sort of boring life about Shelley, it says when she was 15, she noticed that her hands sometimes shook. She could make them still by eating, but the tremor would return. She shook when she felt anxious. She felt anxious about everything. And anyway, it says she graduated in 1988 from Highland High, enrolled in secretarial school. A year later, her birth mother started to look for her. So Norma actually started to try to find her. In 1989, Norma McCorvey attended an abortion rights march in Washington, D.C. She had revealed her identity as Jane Roe after the Roe decision in 1973, but almost a decade had lapsed. Let's see. Norma announced she was hoping to find her third child in a television interview. The Today host, Jane Pauley, and Norma asked Norma why she decided, and Norma struggled to answer. Gloria Allred was her attorney. Allred interjected the decision was about choice, but for Norma, it was already directly connected to publicity, and Norma was being paid for a lot of these publicity stunts. So it's kind of hard to say. It looks like she might have been doing this for the money. And here is a picture of Gloria Allred and Jane Roe in 1949, where they are doing the television circuit looking for her, I guess, her baby. So Gloria Allred's always about the money, but that's Jane Roe in 1989, supposedly looking for her daughter. Let's see. It goes on to say that Norma went public with her hope to find her daughter. They apparently couldn't find her, but I know that from reading another article that this girl knew in 1989 that she found out that she was the Roe baby. This says she found out somebody named Hamp had traced Shelley's path to Washington State. This is after she was an adult, when she was 19. But this was the Roe baby, so she flew to Seattle, responded to the present herself. She was waiting in her van in the parking lot. I guess they met at a Starbucks. I didn't even know they had them back there, but a coffee place. Shelley and Ruth drove to the Seattle Space Needle, and it was kind of a publicity stunt. And when she found out about that, they left. And apparently she knew then that she was the Roe baby, but they kept it really quiet until 2012. All right, so anyway, that's what went on with that. This woman did not know. She didn't want to know. She didn't think that Norma McCorvey had a right to meet her. She never met Norma McCorvey. And so that kind of leads us back to what's more important here, which is the Dobbs v. Jackson Women's Health Organization brief. And I think where we left off last week was sort of Justice Alito, in his opinion, was going through some of the issues that were the core of the Mississippi case. And I want to start there because I thought they were so on point and so important for people to hear the medical advances that have taken place since Roe and some of the things that they had to tangle with when they were looking at the decision, not just the constitutionality and how it was decided in the legal gymnastics that were made in 1972 to 73 when Roe came out, but what they were looking at now. And so I'm going to start with page 6 of the Dobbs opinion written by Judge Alito that's in the draft that was leaked. The law at issue in this particular case is Mississippi's Gestational Age Act, and it contains the central provision that, quote, except in a medical emergency or in the case of severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. And so the Mississippi law goes a little bit further in not just saying you can't do this, but they're defining that you can't have an abortion for an unborn human being, and they're calling it a human being, after 15 weeks. To support this act, the legislature made a series of factual findings. It began by noting that at the time of the enactment, only 6 countries besides the United States permitted non-therapeutic or elective abortion on demand after the 20th week of gestation. So that means most countries don't allow this. The United States is pretty liberal here, allowing abortions after the 20th week. So that's about the 4 or 5 month period mark. And a lot of people don't even show at that point. So that's still pretty mind-boggling if you think about it all over the world. The legislature then found that at 5 or 6 weeks, gestational age, let me see if I don't miss anything. The legislature then found that at 5 or 6 weeks, gestational age and, quote, unborn human being's heart begins beating. That's at 5 or 6 weeks. That's pretty early on. People don't even know they're pregnant at that point. At 8 weeks, the unborn human being begins to move in the womb. At 9 weeks, all basic psychological functions are present. At 10 weeks, vital organs begin to function, and hair, fingernails, and toenails begin to form. At 11 weeks, an unborn human being's diaphragm is developing, and he or she may move about freely in the womb. And at 12 weeks, the unborn human being has taken on the human form in all relevant respects. Quoting Gonzalez versus Carhart, a Supreme Court case that they looked at for the purposes of Roe v. Wade and whether abortion laws were unconstitutional, that was decided in 2007. It found that most abortions after 15 weeks employ dilation and evacuation procedures, which involve the use of a surgical instrument to crush and tear the unborn child. And it concluded that the intentional commitment of such acts for non-therapeutic or elective reasons is a barbaric practice, dangerous for the maternal patient and demeaning to the medical profession. Respondents are an abortion clinic, in this case, Jackson Women's Health Organization, and one of its doctors. So now we know that Jackson Women's Health Organization is really just a shell set up not for women's health, but to provide abortions. And that's not to say that they don't also give them checkups, but they probably, checking them out for the primary purpose of a woman having an abortion. On the day the Gestational Age Act was enacted, respondents, which is Jackson's Women's Health, filed suit in federal district court against the Mississippi officials, just like they did in Dallas against the actual officials, alleging that the act violated the court's precedents, establishing a constitutional right to an abortion. And again, that's just we want to think about this for a minute. If you don't agree with an act, you're actually going to file the elected officials as opposed to just filing suit for a declaratory judgment on whether or not the law is constitutional. That's kind of surprising to me, but that's what you do. And that apparently will get you into the federal district court and on your way to the Supreme Court. The district court granted summary judgment in favor of the respondents and permanently enjoined enforcement of the act. That means that the district courts determined that the Mississippi Act was by summary judgment, as a matter of law, unconstitutional, reasoning that the viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions. And that's really confusing that they're making this up. And that 15-week gestational age is prior to viability. And the Fifth Circuit affirmed this in 2019. And that's just basically men and women on this district court deciding, despite what the facts say, that viable gestational life occurs after the 15th week, even though we have all the what we just went over from the 6th week on. We've got heartbeats and vital organs that begin to function in hair and females. They're still saying, and I think you can even live by the 15th week, but I'm not sure about that yet. They'll talk about it later here. So the district court decided that viability, in their opinion, was if it was before that point, then a woman could make this decision. So that's just, dumbfounds me that people that aren't doctors and having these findings of fact would make that decision. This goes on to say that, as a footnote, gestational limits on abortion in the United States compared to international norms show that an article, is the United States one of 7 countries that allow elective abortions after 20 weeks of pregnancy? And that was written in 2017, stating that the claim made by the Mississippi legislature and the Charlotte Lozier Institute was backed by data, so that they were telling the truth. They just weren't making this up to be pro-lifers. A more recent compilation from the Center of Reproductive Rights indicates that Iceland and Guinea-Bissau are now also similarly permissive. So they have become liberal as well. Okay, so this goes on to say that the Supreme Court granted certiorari to resolve the question whether, quote, all pre-viability prohibitions on elective abortions are unconstitutional. So that was the only question before the court in this case. Are all pre-viability, as they have determined as a matter of law, viability is after 15 weeks, prohibitions on elective abortions unconstitutional? Petitioner's primary defense of the Mississippi Gestational Act is that Roe and Casey, which was a 2017 case that was also on abortions, were wrongly decided and that the act is constitutional because it satisfies a rational basis review. And that's what I was looking for before. You have a different levels of review under the Constitution, and rational basis is one of them, and that would hold muster. Respondents answered that allowing Mississippi to ban pre-viability abortions would be no different than overruling Kay and Roe entirely. And they tell us that, quote, no half measures are available. We must either reaffirm or overrule and Roe and Casey. We begin by considering the critical question whether the Constitution, properly understood, confers a right to obtain an abortion. Skipping over that question, the controlling opinion in Casey reaffirmed Roe's central holding, based solely on the decision of stare decisis. But as we will explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. We therefore turn to the question that Casey plurality did not consider and readdress that question in 3 steps. First, we explain the standard that our cases have used in determining whether the 14th Amendment's reference to, quote, liberty protects a particular right. Second, we examine whether the right at issue in this case is rooted in our nation's history and tradition, and whether it is an essential component of what we've decided as, quote, ordered liberty. Finally, we consider whether a right to obtain an abortion is supported by other precedents. Constitutional analysis must begin with the language of the instrument of Gibbons versus Ogden in an 1824 Supreme Court vision, which offers a fixed standard for asserting what our founding document means. And this goes on to say that we overturn Roe versus Wade. And so and then of course we're going to have now a part 4, because I have to start with page 10. It's a long opinion, but it's so well written. It's something that we cannot miss and you must listen to. So please tune back in again next week. We will see you on the Legal Connection Show Tuesdays at noon. If you want to listen to this broadcast again, go to our website or irlonestar.com and look up the Legal Connection Show. And remember, the most important thing that you can do this week is to serve God by serving others. And we'll talk to you next week.